So, as far as defenses go, generally for cases that we've encountered where somebody is dealing with copyright infringement action, usually what we're looking to do is resolve the case by way of settlement, the other side. Usually that is the best option, mainly because if you have in fact downloaded the material illegally and infringed on another person's copyrighted works, then your defenses become rather limited with respect to fighting it in court. And again, that could be a very costly route through attorney's fees and having to run the risk of whatever the judgment is that's entered by the judge. And so, as far as cases go, every case is handled on a case by case basis. Each situation is unique. There is no like blanket one size fits all approach to legal matters. So even when we are settling cases, we do have to do it with a strategy in place. Sometimes our client is looking to remain anonymous for, whatever reason, just based on principle. They don't want their name to be dragged through the court, or they'd like to protect their own assets and not have their name be made public. So sometimes the strategy is not to involve our client's name and information. In some instances, we're able to present mitigating factors. For example, one time we represented a nonprofit and was able to prove that, yes, there was an infringement. However, clearly it wasn't intentional and there was no money being made by our client at that time. And it was a mistake. And so we were able to defend our client and resolve it without client spending a whole lot of money. And that was all done outside of court.